it really is very troubling. Can I ask you, the Foreign Intelligence Surveillance Court, as you have pointed out, considers the application of a foreign intelligence surveillance for a warrant by the FBI working with the National Security Division at the Department of Justice. Do you believe if the court knew what you know now, that it would have ever issued the FISA warrant in the first place?
We're careful not to predict what federal judges would do, presented with the evidence, and whether there would be sufficient basis to find probable cause. I know that they would not sign a warrant if they were told not all relevant information was included in it.
Or if they were lied to.
And certainly if they were lied to.
And do you know whether the court is currently considering this matter?
Well, I know the court, based on discussions with folks at NSD, at the National Security Division, that they have the report and that they have a follow-on letter from the department about this matter.
Well, I hope they will not let this pass, because if this misbehavior, this illegality, this deception becomes a routine, I agree with Senator Graham that it will be the end of the authorities that Congress has granted under the Foreign Intelligence Surveillance Act, which I think would be very damaging to our national security. The Foreign Intelligence Surveillance Act includes the word surveillance, obviously, and you can't surveil an American citizen for intelligence purposes except under very specialized and exacting circumstances. Would you agree with that?
That's correct.
Because the rights given to an American citizen under the U.S. Constitution are laid out in the Bill of Rights, among other places, and there is a higher standard with regard to getting a warrant, let's say, to wiretap or to investigate an American citizen than there would be a foreign agent, correct?
That's correct. There's particularly sensitive circumstances around surveilling a U.S. person.
So the whole exception here, which authorized the court authorized the surveillance of Mr. Page, was based on some proof or some indication, some suspicion he was an agent of a foreign power, correct?
Correct. They had to show probable cause to believe he was an agent of a foreign power.
But as you pointed out, they got incomplete and misleading information in that process. Agreed?
The court got inaccurate, incomplete information. Agreed.
So what's the difference between surveillance and spying?
Well, surveillance, and the term I'm going to use and we use in the report, is what's in the law, the Foreign Intelligence Surveillance Act.
You don't like the vernacular?
I'm going to stick to what we do as IGs, which is look at the law and stick to what the language is in the law.
Well, to my mind, there's really no difference, although it's legally authorized according to the Foreign Intelligence Surveillance Act. It's an active covert intelligence gathering against a foreign power or an agent of a foreign power. Let me ask you about the defensive briefing.
Yep.
And you've explained in response to Senator Graham's questions the difference between a counterintelligence investigation and a criminal investigation. And I believe at some point during the last few years, I remember Loretta Lynch, the former Attorney General, say that defensive briefings were routine in counterintelligence investigations. Would you agree with that?
You know, I frankly don't have enough experience with them on the national security side to tell you one way or the other.
You don't have.
I've heard that be said, but I don't know specifically.
You don't have any reason to disagree with?
No reason to disagree.
Okay. So if they are routine, if Attorney General Lynch is correct, the decision by Mr. Priestap, the head of the counterintelligence division of the FBI, not to provide an extensive counterintelligence briefing, defensive briefing to candidate Trump in his campaign would be unusual.
If it's usual, then not doing it, yes, I agree, would be unusual.
What was even more unusual is the fact that when the Director of National Intelligence went to provide what turned out to be a perfunctory briefing to the Trump campaign, lasted about 13 minutes, I think you indicated in your report, that they had implanted into that group an agent, FBI agent that was part of the investigative team for a crossfire hurricane. Is that correct?
That's correct. The agent, there was one FBI agent there, and they chose the agent from the counterintelligence investigation.
So instead of their mission being to provide candidate Trump and his campaign, to arm them with information so that they could prevent the Russians from infiltrating their campaign, this briefing, such as it was, had a dual purpose. The agent, it says on page 342 of your report, actually prepared himself going through mock briefings headed by Stroke, Lisa Page, the Intel section chief, and possibly the general counsel unit chief, correct?
That's correct.
So this was not just an incidental sort of thing. Obviously, there were plans made for the agent to go in as part of this defensive briefing and perhaps get General Flynn to inadvertently offer information that might be helpful to the FBI in their investigation.
Yeah, and as explained to us, it was dual purpose. One, to see if anything was said during the briefing in response to the briefing that would be useful for Crossfire Hurricane purposes immediately, but also, as the agents told us, for purposes of a future interview of Mr. Flynn, which did in fact occur later.
And so Mr. Flynn was clearly the target.
He was certainly, of the three people there from the Trump campaign, the only one of the three who was a subject of an FBI investigation at the time.
And he wasn't told that he was under investigation or that the agent was there hoping to bait him into providing incriminatory information, and the agent didn't provide him any declaration or admonishment of his Miranda rights, correct?
He certainly wasn't told there was a dual purpose to the briefing.
Well, it looks to me like Director Wray was so concerned about this that he's, as you pointed out, said that this will never happen again.
That's right.
Is that what you said?
That's correct.
So let me ask you, Mr. Horowitz, are you familiar with the fact that Director Comey had a meeting with President Trump in January of 2017 to talk to him about the Steele dossier?
I am, and we actually referenced that in our report about his preparation and handling of the memos that came out of that meeting.
Why should we believe that Director Comey's so-called defensive briefing, if you want to call it that, of the president in January 2017 was anything more than an attempt to try to bait the president into providing incriminatory information which would be useful to the FBI in its counterintelligence investigation or potentially some future criminal investigation?
I have no information one way or the other to make a judgment on that, but as mentioned earlier, one of the concerns with doing that here is that it leaves open the possibility that people might ask, did it happen elsewhere?
Well, it strikes me as fraught with danger, just like it was for General Flynn, for the director to go into the White House, the Oval Office in the White House, not to tell the president that anything he says could be used against him in an ongoing investigation, potentially including criminal charges. And the final thing I would say is I agree with the chairman. If this is going to happen to a presidential candidate or the president of the United States, what kind of protection do average American citizens have that their government won't array this vast power against them and essentially ruin their lives? To me, that's a profound concern as a result of your investigation.
Thanks, Mr. Chairman. And picking up on that editorial comment, I've been joining Senator Leahy and Senator Lee for years talking about this FISA court. Yep. And we now have an ample